Hello and welcome to the program. I am DEJI360. After a long-drawn legal battle, litigations on Nigeria's 2023 presidential election is now effectively over. The country's Supreme Court on Thursday ended the 171-day legal tussle to nullify the election of President Bola Tinubu with a dismissal of the election petition appeals now filed by the presidential candidates of the People's Democratic Party, Atiku Abubakar, and Peter Obi of the Labour Party. Atiku and Obi's election petition cases commenced May 8 and concluded October 26th, with the Supreme Court effectively ending their dreams of overturning Tinubu's electoral victory. In the legal judgment delivered by the chairman of the seven-man panel, Justice John Inyang Okoro, the Apex Court now dismissed all 7 grounds of appeals by the petitioners, including Atiku's quest to tender fresh evidence over allegations of certificate forgery against the president. Now, specifically now on the fresh evidence, the Apex Court ruled that it no longer had the requisite jurisdiction to admit new document in the case. The justices noted that the forgery issue which Atiku sought to establish through the proposed fresh evidence was not pleaded in any paragraph of his appeal. Citing sections 14(2)(a) and 132 of the Electoral Act, Justice Okoro said a petitioner is not allowed to amend his petition after the stipulated 21 days, let alone provide fresh evidence. The court also held that Atiku did not prove that the Independent National Electoral Commission, INEC, did not substantially comply with the provisions of the Electoral Act. The court said the same thing actually on Obi's petition as well. On the failure of INEC to transmit the result to IREF, the 7 justices said the non-transmission of the results to the IREF portal did not affect the outcome of the poll, upholding the tribunal ruling that the IREF is not a requirement for collation of results. On the claims of manipulation of election, the court described Obi and Atiku's witness testimonies now as hearsays, as there were not polling agents directly involved in the electoral process from the various polling units. On the controversial issue of the status of the Federal Capital Territory in a presidential election, the Apex Court affirmed the position of the Presidential Election Petition Court that the FCT does not have a special status that is more special now than that of the 36 states of the Federation, and that the Constitution does not require that a presidential candidate must score 25% of votes there. Now, on the ground that the result that was declared by INEC was not accurate, the court averred that Atiku and Obi, and of course, as well as the PDP, failed to put forward their perceived rightful results. The court also said the issue of the alleged double nomination of Vice President Kashim Shettima ought to have been brought before it, saying the matter had earlier, ought not to have been brought before it actually, that the matter had earlier been resolved by the court. Finally, the court ruled that Atiku and Obi's petitions had no merit and consequently resolved all the issues in favor of the respondents. Let's talk some more now about the court ruling. Joining me on the show right now is Chief Robert Clark, a senior advocate of Nigeria and one of Nigeria's topmost constitutional lawyer. Thank you very much, Chief, for joining us on the program. I'm absolutely sure this ruling does not come to you as a surprise, because right from the get-go, you had said this case was going nowhere.
Well, right from the word go, on the judgment of the lower court, I was always clear in my mind that there was not enough evidence brought before the tribunal that will have moved any court to claim that the election was not in accordance with the Election Act. In respect of the new additional evidence, it was very clear that you cannot build something on nothing. There was no evidence that this piece of evidence, which Atiku now wants to bring into the proceedings, was ever brought before the lower court to have enabled the appellant to have used it as a form of appeal, because the Supreme Court only deals with matters that relate to evidence already adduced before the lower court. So it was very clear in my mind that all the grounds of appeal went to no issue and all will be thrown away. And I've been proved right. I've been proved right.
But Chief, let me even ask you this. As a lawyer, one would expect that the lawyers to the petitioners ought to have known, for instance, that they cannot plead new evidence at that stage of the case. Why did they give it a try?
Well, I cannot read their minds, but I can speak from experience. The problem in Nigeria is that election petition is the time the lawyers call a harvest period, where monies they have not been able to make from any form of practice they were pursuing, that was the period they will now harvest all their gains from legal practice. You see, not that lawyers are, that there are bad lawyers or good lawyers. I wouldn't say that. But the ability to deal with matters that will be debated before a tribunal is within every lawyer to know. If this brief has been brought to my chambers, I will have told Atiku that, look, I will not handle your brief because there is no merit in it. But the question is, how many lawyers will reject a brief that is tied with Naira zone or Naira money, or, and with boldface tell a client that I'm not taking your brief. But I am shocked looking at the caliber of lawyers that Atiku has surrounding him, that one single one of them should have been able to talk directly to Atiku and tell him straight that there is no merit in your brief. How can we say we should bring in an evidence which, one, has run out of time under the Act? You can only bring this evidence, even if it were available then, within the period the tribunal says you must bring in it. You did not bring it in. Secondly, when you wanted to bring it in, you did not bring in it during the trial at the lower court. You are now bringing it in the appellate department of the Supreme Court. And it's an original evidence which has to be proved beyond reasonable doubt and has to undergo many phases of the law before it is admitted. So I am shocked that even these facts are known to the lawyers. They still went ahead to tell their supporters that there's going to be a surprise at the election tribunal in the Supreme Court. I don't know how to describe it. I wouldn't say it is a scam. I wouldn't say it's something else. But I, Robert Clark, would not have accepted such a brief.
All right, Chief. Another thing I want to ask you, and this issue came before the Presidential Election Petition Court. That's the lower court now, and the justices of the Supreme Court did highlight it as well. This issue of the parties now. I'm talking about the lawyers now not presenting any polling unit agent as a witness, and that is a big surprise for me. As a lawyer, would you say that was an oversight on the part of the lawyers of the petitioners, or it was a strategy that backfired?
Look, I'm not used to criticizing the practice of lawyers at the tribunals or courts. It has never been my practice. It's only because this item of negligence or dereliction of duty has been attributed to lawyers that I am even going to say something about it. But I will ask you to take it from me that I don't feel happy talking about the dereliction of duty by lawyers. Please bear with me on this occasion.
I understand you. Now let's talk about the issue of the FCT. It became very controversial immediately after the results of the election was declared. Most of us didn't even know the issue was going to be one of the grounds of appeal. But then, one of the grounds now for the petition, it became an important ground for the petition. And of course, you could see the petitioners took it up to the Supreme Court. Give me your take on the way the Supreme Court ruled on that. Of course, upholding the decision of the lower court.
You see, the tribunal is to decide according to the law. The law is so clear that INEC, in the use of transmission of results, has to do certain things. The law is clear about it. And what the appellants are now saying is that despite and in spite of what the law says, they are still asking the Supreme Court to deal with the matter in another manner which is contrary to the law. The Act says INEC must perform its duties in the following manner. If they are in dereliction of that manner of doing things, you have to bring the facts to the Supreme Court that rather than doing what the law says they should do, this is what they did. But you did not point out anywhere in the law, because INEC says, look, there is no part of the law that says I must do this, I must do that. And I never did it. I used my discretion because of certain circumstances that were prevalent during the election period. If you, as its lawyers are now talking, that INEC is in dereliction of its duties, then bring those facts out. And they couldn't. So it is clear that INEC acted in accordance with the law. And justice must be according to law also. Because any justice that is not based on the law is no justice. So I agree that their claim in the lower court was thrown out because facts were not brought by any of their lawyers. Facts are not brought by them that what INEC did was not according to the law.
Chief, are you surprised that the issue of the FCT, that's 25% votes in Abuja, became a very big issue where there was a huge contestation whether the Constitution actually required that a presidential candidate must score 25% of the votes in Abuja? Of course, the Supreme Court has laid the matter to rest now, but are you surprised that it became a very big issue and one of the grounds of appeal?
I was surprised because right before the litigation in the lower court, the Supreme Court had laid to rest that no specialty will be attached in any manner, in any way, in respect of any issue raised in the law of Nigeria or Constitution of Nigeria that gives Abuja any preference over certain acts. The Supreme Court had made profound findings of facts on this issue that Abuja does not enjoy any privilege over any other state, because although it is not a state then as prescribed in the Constitution, it enjoys the status of a state. But in enjoying this status, no circumstances will permit Abuja to accept or be given any privileges. So what the lawyers of Atiku are now claiming now is that by the strict interpretation of that section, it has given Abuja a privilege well over all other the 36 states. So the Supreme Court has made profound findings of fact. And I'm shocked that Atiku's lawyers could still raise it up to the Supreme Court when the Supreme Court on different cases, 2 or 3 other cases I'm aware of, had made profound findings of facts. And they let me use the word. The Supreme Court was pissed off that after we had made these profound findings, you still come to us that will make another finding against what we did before? No, that is not the law. So the Supreme Court did what is expected, followed its decisions in other areas, followed the route they've been going in other cases in respect of matters affecting Abuja. So that judgment is so sound, and it cannot be touched by anybody.
Chief, let me ask you this final question. It's really a worry that after elections in this country, whoever is declared a winner is still not considered a winner until the court has a final say. So seemingly giving the impression that it is actually the court that declares the winner of an election in this country. How worrying is that? When exactly are we going to go beyond this issue of waiting for the courts to decide on who actually won election in this country? Because, I mean, you look at the presidential elections we've had in this country from 1999 to date, all of them have been challenged in court, up to the Supreme Court.
Let me be frank with you. As we are going today in Nigeria, as we are looking forward to another election under the basis of this 1999 Constitution, we shall always be having problems as we are having today. The problem is not in us that we are Nigerians. The problem is in us that the Constitution that was handed over to us in 1999 makes it impossible to alter or redefine the Constitution. You ask me why. A society develops from circumstances that comes through its way every time. We have had 3, 4, 5, 6 elections, and we are still saying the same thing. We go to court, and until a determination is done, everybody says different things about how the election went. Why is it? When we know what is wrong, number one, what is wrong in Nigeria today is the political parties. The political parties have hijacked the whole system of governance in respect of the constitutional rights of everybody in respect of the election petition. If you are not a member of a party, you cannot contest for an election. If you are not a member of a party, you cannot be voted for. The political parties now dominate the whole trend of Nigeria, and they are causing all this problem, and they will continue to cause the problem because they are benefiting from it. Now, what we need in Nigeria is to allow that section which says there are no independent candidates. Once that section is removed from the Constitution, a constitution that has already guaranteed us the fundamental human rights theory. Now, having granted us that all Nigerians have equal rights, you are now telling us that even though we have equal rights, but there is one area of law, no Nigerian has the same right, election. Therefore, that thing comes and will continue to come forward every election time. So, if that section is not removed, we will never make it in election petition. And who are those who amend it? Those who can only amend that section are the same people who are enjoying the benefit.
Exactly.
You cannot amend a constitution without going through the National Assembly. And all these are members of political parties that are making all the money. And that is why people have to spend money and money to the extent of killing themselves to get nomination to contest election, because you have to pass through the noose of a needle. So, to amend the Constitution, something has to be done. The people who are to amend it will never amend it. Let us be honest ourselves. Because they are making money from it. They are making power from it. They are making many things to themselves. The question is, how do we amend? I always tell my friends that I leave it to the power of God. God, in His infinite mercy, will look at us as Nigerians. Give us the privilege and the understanding to amend our Constitution. It is when the Constitution is amended that a third party, an independent party, can join it and remove the cobweb that political parties have put into our mind. How do you know? In every election in Nigeria, under this constitution, which I'm aware of, over 1,000, cases go before the court. Maybe about 100 of them get to the Supreme Court. Where is the time for other matters to go on? So my prayer is this. Let some few Nigerians who can make a leadway pray to God, because that's the best all of us can do in the circumstances. That's nothing any one of us can do. We cannot change it. Pray to God to give us the grace and understanding to amend the Constitution. Thank you.
All right. I'll join in that prayer as well. Chief Robert Clark, thank you very much for coming on the show, and thank you for talking to us.
Thank you.
Thank you very much, sir. All right, we'll take a short break and we'll be right back. Stay with us. Don't go away.
Opinions are free. Facts are sacred. But truth is universal.
How, in practical terms, can we, for instance, de-escalate the tension?
President must see himself as the President of the Federal Republic.
We know where the enemy is. 3 places. The Lake Chad Basin, the border area between Nigeria and Cameroon, and then the Sambisa Forest.
On DEJI360, we give you a complete dose of everything. Opinion, facts, and undiluted truth.
I hardly believe what politicians say in this part of the world.
A new Nigeria is possible, a future is possible.
We delve into the issues, dissect it so that you can understand it, and use it to take action.
I don't think there's any need for any governor to look for grant for ranching.
DEJI360, dissecting the issues.